Hello, everybody. I'm back again with another Sassy True Crime video. Today, I'd like to take a deep dive into a case I introduced in my last video, which is the Arthur Wildgoose case. This man, Arthur Wildgoose, is currently serving a 30-year sentence for first-degree aggravated sexual assault of a child under 13 and endangering the welfare of a child. Just to give a quick recap, I'm familiar with the Arthur Wildgoose case because once upon a time, I was a friend of Arthur Wildgoose. He was one of my ex-husband's best friends, and I would say from 2003 to 2010, me and my family spent a lot of time around Arthur and his family. After I divorced from my ex-husband in 2012, I lost touch with Arthur Wildgoose for a couple years, but then in 2014, Arthur reached out to me out of the blue and he asked me to go out for dinner and drinks. I didn't feel comfortable doing that with my ex-husband's best friend, so I declined. But I just want to point out and stress, because I saw some comments in my previous video commending me for being smart enough not to take Arthur Wildgoose up on his offer. But I didn't decline Arthur Wildgoose's invitation to hang out because I felt he was creepy or that something was off. He seemed like a normal guy. He was a jokester, he was witty, he worked, he seemed like a good father. No red flags in my eyes. There was no feeling at the time when he asked me out that I felt I should be cautious or even felt that there was any danger to have this person around my child. So that's the scary part for me. You literally just have to be cautious of every person you have around your young child. So Arthur Wildgoose, since his sentencing, has filed numerous appeals. And today I want to go over the appeal that he submitted in November 2018. So let's take a look at that. Okay, so this is the Superior Court of New Jersey, Appellate Division, docket number A2303, 17T3, and it's the State of New Jersey versus Arthur Wildgoose. Submitted November 28th, 2018, and it was decided on December 24th, 2018, before Judges Kolblitz, Currier, and Mayer. And this is on appeal from the Superior Court of New Jersey, Somerset County. And it's Ronco, Lowen, and Benucci are the attorneys for the appellant, and Michael Robertson, Somerset County prosecutor, attorney for the respondent. A jury convicted defendant Arthur Wildgoose of first-degree aggravated sexual assault and third-degree endangering the welfare of a child. He appeals from his January 11, 2018 conviction, an aggregate sentence of 30 years in prison with an 85% parole disqualifier pursuant to the No Early Release Act. So that means that he would have to serve 25 years before he would be eligible for parole. Defendant, 32 years old at the time of the incident, was convicted of having a sexual relationship with a 12-year-old girl, BP, which are the initials that they use for the victim, for 1 month that culminated in an act of vaginal penetration. Defendant had befriended BP's mother, CP. He became close with CP's family, eventually sleeping over at CP's house on several occasions, during one of which defendant committed the act of penetration. At trial, the relationship was corroborated by more than 2,000 text messages between the defendant and BP. Defendant argues the following errors by the trial court, which were not objected to at trial, require reversal of his conviction. 1A, the incorrect date in the indictment. 1B, the definition of sexual penetration in the jury instruction. 2, the lack of instruction of a lesser included offense. And 3, prosecutorial misconduct. After reviewing the record in light of the contentions advanced on appeal, we affirm. 1. Trial. The trial revealed the following facts. In December 2014, defendant met CP and her children while defendant and CP coached youth basketball in the same gym. Defendant was a divorced father of 2 young children. CP was a single mother of 3 girls, including 11-year-old BP. Defendant and CP began socializing, and defendant invited CP and BP to play basketball with him and other people in February 2015. Defendant visited CP for Sunday family dinners and spent entire weekends at CP's home, with at least one of CP's daughters always present. CP developed a romantic interest in defendant, but defendant repeatedly told her that although he was interested in her also, they would have to find time to do that when they don't have the kids or when they had free time, which was limited because of their busy lives as single parents. Defendant and CP never went on a date alone or pursued a sexual relationship, and their activities always included CP's children and sometimes defendant's children as well. Defendant took an interest in helping BP with basketball. He went to the gym and watched BP practice, after which BP stayed with defendant until he brought her home. Defendant, a tow truck operator, took BP with him on calls. He also took BP with him to spread birdseed and apples to attract deer where he hunted. In April 2015, BP turned 12. Defendant asked CP to bring BP to his house so he could give BP a 6-foot teddy bear that smelled of defendant's cologne, as well as balloons, a Yankee shirt, and lottery tickets. The birthday card read, "Happy birthday, BP. I hope you have an amazing day. I hope you got everything you wanted. Have a happy birthday. Love, AJ. XOXOXO." In October 2015, BP and defendant began texting through their cell phones. Defendant asked BP if she would be his girlfriend, and she responded yes. BP testified that this made her feel very important and special because an older person wanted to be with me. Defendant called her beautiful and referred to her as babe and baby. Defendant told BP that he loved her multiple times a day, both in person and through text messages, and BP responded that she loved him too. Defendant told BP that he wanted her, missed her, and wished he could see her more. Defendant expressed to BP in text messages how it sucks that they cannot walk around as a couple because he could get in trouble. Defendant told BP, "We can't tell anybody about this, and you can't tell mom. Don't tell her. Don't tell her anything." BP testified that defendant instructed her every day to delete everything because he knows her mom checks her phone and she would see everything that they were talking about. In November 2015, defendant began rubbing BP's back, shoulders, arms, and stomach and kissing BP on the cheek and lips while they were alone in CP's basement. Defendant told her he could go to jail if anyone found out about what he was doing with her. BP developed a canker sore on her tongue when defendant simultaneously had a sore on his mouth. CP confronted defendant asking if he had been kissing her daughter, and defendant denied having done so. Between November 12th and 13th, 2015, defendant and BP discussed their excitement regarding defendant's upcoming sleepover at CP's house and how they wanted to have a baby together. Defendant sent a text to BP saying, "I really do like you. There isn't a minute that goes by that I don't think about you. If anything happens, then it does. If we are both in the mood, then it's right. Our children will look beautiful. I want the baby to look like you because you are gorgeous. I just want the baby to have my last name." Defendant asked BP, "How bad do you want me?" To which BP responded, "Really bad." Defendant then asked, "You want me in you?" To which BP responded, "I don't know." More text messages followed regarding what BP's mother would say if BP became pregnant, and defendant sent text messages saying, she won't know about the sex unless you tell her, and please delete." BP testified that on Friday, November 13, 2015, while defendant was sleeping over at CP's home with his 2 children, defendant pulled her from the air mattress onto the futon with him and vaginally penetrated her. BP testified that defendant kissed her stomach, arms, and lips. And then he started taking my pants down and he grabbed my hand and put it on his private parts and made me touch him. And I pulled away because I didn't want to. And then he rolled me onto my side and then he penetrated me. She noted that her back was to him and she knew she had been penetrated because it was kind of like how a tampon felt. That's how I knew his private parts was in my private parts. Defendant then looked up the Plan B pill on his phone, handed his phone to BP, and BP read about how Plan B is used to prevent pregnancy. Defendant then told BP he could get it from a pharmacy the next day. None of the other children stirred or awoke. Sick. The next day, defendant approached BP after her soccer game while CP was coaching on the field, which is her mother, and gave BP a loose pill that he told her was the Plan B pill, which BP took. And then there's a note that says video surveillance of a pharmacy in Bridgewater from the morning of November 14, 2015 shows defendant pulling into the parking lot, walking straight to the aisle where Plan B pills are displayed, pausing for a moment, and then exiting. Other text messages between defendant sent a text saying, "You have to let me know when you get your period." Other text messages between defendant and BP concerning sexual behavior and defendant's efforts to maintain secrecy were shown to the jury. The following month, BP approached her mother, visibly upset and crying, and told her that defendant took her virginity. CP contacted the police. In March 2016, BP attempted suicide and spent 24 hours in the hospital. That is just horrible. Okay, now we have what the defendant is arguing on appeal. Defendant argues on appeal. Point 1. The trial court's failure to amend the indictment and corresponding language of the jury instructions to allege one act of sexual penetration on November 13, 2015, combined with the court's failure to provide a simple affirmation response to the jury's questions whether it needed to find penile penetration to satisfy the sexual penetration element of aggravated sexual assault, and giving instead a re-instruction on penetration which included various sexual insertions that were not in evidence. Intermissibly posed a danger of a verdict based on speculation as to when and what type of penetration was committed instead of on the evidence presented. Point 2. The trial court plainly erred in not instructing the jury sua sponte that it needed to consider second-degree sexual assault as a lesser included offense of aggravated sexual assault. Point 3. The prosecutor engaged in misconduct on summation which deprived Mr. Wildgoose of a fair trial. And point 4. Mr. Wildgoose's sentence was manifestly excessive and must therefore be vacated. Indictment. First, defendant argues on appeal that the trial court erred in denying this mid-trial motion made after the indictment was read and evidence presented to the jury to amend the indictment because it provided a date range suggesting multiple instances of penetration. Second, in the same point, defendant argues that the trial court erred by giving an instruction to the jury on penetration that included various methods of sexual penetration not suggested by the evidence, contending that this instruction allowed the jury to base the verdict on speculation as to what type of penetration took place. When an indictment charges a sex crime against a child victim, a charging document does not need to specify the date of abuse, so long as the indictment otherwise gives the defendant sufficient notice of the crime to prepare a defense. Moreover, objections based on defects in the indictment, barring certain inapplicable exceptions, must be raised before trial and are otherwise waived unless the court grants relief from the waiver of good cause. Here the indictment reads, from on or about the first day of October 2015 to on or about the 29th day of November 2015, defendant knowingly did commit an act of sexual penetration upon one Jane Doe, when Jane Doe was less than 13 years old. The prosecution referred to a single act of penetration at trial, stating to the jury that defendant had sexual intercourse with BP on the night of Friday, November 13th, 2015. The prosecutor discussed text exchanged in the days following Friday, November 13th, which referred to wanting to do that again, what we did last Friday, and how the following weekend involved a brief touching of defendant's penis. The prosecutor presented evidence to suggest penile penetration, such as the discussion of Plan B pills in pregnancy, and closed by stating to the jury that's the night he penetrated her with his penis. Okay? And you'll see this evidence of the sexual talk that day. The trial court noted defendant did not file a motion to dismiss the indictment or seek a bill of particulars pursuant to Rule 3.7-5. We agree with the trial court that defendant was given adequate notice through the discovery process and was aware of the nature of the charges when he was first arrested. Regarding defendant's second argument pertaining to the jury instruction on sexual penetration, an essential ingredient of a fair trial is that a jury receive adequate and understandable instructions. The test to be applied is whether the charge as a whole is misleading or sets forth accurately and fairly the controlling principles of law. The evidence and focus by counsel for both parties throughout trial centered on one instance of penile penetration. The trial court instructed the jury, consistent with the definition in NJSA 2C-14-1. The first element that the state must provide, but beyond a reasonable doubt, is that the defendant committed an act of sexual penetration with BP. According to the law, vaginal intercourse between persons constitutes sexual penetration. Any amount of insertion, however slight, constitutes penetration. That is, the depth of insertion is not relevant. The definition of vaginal intercourse is the penetration of the vagina or of the space between the labia majora or outer lips of the vulva. During jury deliberations, the jury asked the court, does vaginal intercourse require that the penetration be done with a penis? Without the jury present, the trial court read aloud to counsel for both parties. According to the law, vaginal intercourse, cunnilingus fellatio, and I'll just read the whole thing, anal intercourse between persons or insertion of a hand, finger, or object into the blank, I can't read all these words, either by the defendant or by another person upon the defendant's instruction constitutes penetration. Defense counsel did not object to the clarification, but did express his reservations. I guess the problem is, and this is the defense attorney, I guess the problem is there's zero evidence that it's anything but a penis. I don't know where they're going with it. Your Honor's recital is an accurate recital of the law. The trial court proceeded to instruct the jury as it suggested. Any error in the court's instruction is harmless unless, in the light of the record as a whole, there is a possibility that it led to an unjust verdict. That is a possibility sufficient to raise a reasonable doubt that the error led to the jury to result it otherwise might not have reached. All right, let's go down to, defendant argues that the trial court had a duty to instruct the jury only on the law applicable to the facts developed at trial. However, the charge was responsive to a question from the jury. Our jury's prudence does not allow us to conjecture regarding the nature of the deliberations in the jury room. Defense counsel made no alternate request in response to the jury's questions. It is within the sound discretion of the trial judge to decide when and how to comment on the evidence. An accurate definition of sexual penetration in response to a jury question does not constitute error that led the jury to a result it otherwise might not have reached, especially in light of the overwhelming evidence of defendant's guilt. Lesser included offenses. Defendant argues on appeal that he was denied a fair trial because the trial court did not sua sponte instruct the jury to consider second-degree sexual assault as a lesser included offense of the aggravated sexual assault. Pursuant to the plain error rule, where an error has not been brought to the trial court's attention, the appellate court will not reverse on the ground of such error unless the error is clearly capable of producing an unjust result. 2. Our Supreme Court has stated when a party does not object to a jury instruction, this court reviews the instruction for plain error. The court shall not charge the jury with respect to an included offense unless there is a rational basis for the verdict convicting the defendant of the included offense. Therefore, to justify a lesser included offense instruction, a rational basis must exist in the evidence for a jury to acquit the defendant of the greater offense, as well as to convict the defendant of the lesser unindicted offense. When the parties of a criminal proceeding do not request that a lesser included offense be charged, the charge should be delivered to the jury only when there is obvious record support for such a charge. Thus, when the defendant fails to ask for a charge on lesser included offenses, the court is not obliged to sift meticulously through the record in search of any combination of facts supporting a lesser included charge. Only if the record clearly indicates a lesser included charge, that is, if the evidence is jumping off the page, must give the court the required instruction. The jury was instructed that the defendant had been charged with both first-degree aggravated sexual assault and third-degree endangering the welfare of a child. Second-degree assault would have been established by showing that the defendant engaged in sexual contact with BP. The evidential basis for the aggravated sexual assault charge was BP's testimony that defendant vaginally penetrated her. The defense was not that defendant had committed sexual contact without penetration. No evidence clearly indicated second-degree sexual assault rather than the most serious first-degree charge. Prosecutorial misconduct. Also, as plain error, defendant argues that he was deprived of a fair trial because the prosecutor should not have interjected her personal assessment of evidence, citing State versus Aker. A prosecutor may not argue conclusion not reasonably drawn from the evidence, or which rely upon a false foundation. Defendant refers to the prosecutor's explanation of her failure to present any text messages from November 14, 2015, the day after the alleged penile penetration. She told the jury on summation that the texts were omitted to avoid culminative evidence. Defendant alleges that the prosecutor's summation unfairly denied defendant the opportunity to draw reasonable doubt from the omission of these text messages. We afford prosecutors considerable leeway in closing arguments so long as their comments are reasonably related to the scope of the evidence presented. A new trial is required only if the comment was clearly and unmistakably improper and must have substantially prejudiced defendant's fundamental right to have a jury fairly evaluate the merits of his defense. Okay, so during defense's counsel summation, he invited the jury to draw reasonable doubt from the prosecutor's omission of text messages from the day following the alleged penetration. Defense counsel, but on the 14th, we know BP told you, defendant, and I text. Her mother said, we text. Why? Of all the text, those are the texts you don't have. I submit that goes with what's called reasonable doubt. Why don't you have them? Just take a look at what could possibly be contained. And the prosecutor objected. And then they had a sidebar. Prosecutor, that's speculation because what could possibly be contained in reality if the defendant had read the text? I can't comment on his failure to introduce that which he was provided in discovery, but they shouldn't be invited to think about what could possibly be contained because they're told they're not allowed to base their decision on blind speculation. During the prosecutor's summation, she read the contents of several text messages spanning several dates. She then noted the need for practicality and responded to defendant's invitation for the jury to speculate as to the absence of the text messages from the day after the alleged assault. You can see in an effort to read the entire conversation how it can be tedious because there's a lot. There's just banter back and forth. And that's why every text I present to you, the relationship would have been impossible. The defendant would have you hold that the state is hiding something. I submit to you it's just a practicality. By the end of this case, if you don't know already, you will. This relationship is what the state has presented it to be through the witnesses and through the texts. It's just a matter of practicality. You can't have 20,000 texts, but I submit to you, you have plenty here. The prosecutor thus responded to defendant's direct attack during his summation, as the trial court invited her to do, and without objection from defense counsel. The prosecutor's arguments were not made in reliance of a false foundation or for the purpose of partaking personal knowledge of facts not in evidence. The prosecutor's conduct was not clearly and unmistakably improper, nor did it render the jury incapable of fairly evaluating the merits of the defendant's defense. To the contrary, the prosecutor did no more than balance the scales. Sentence. Defendant argues on appeal that his 30-year sentence is manifestly excessive and that the matter should be remanded for resentencing. He contends that the trial court was placing a burden of production upon him and penalizing him for availing himself of his constitutional right to assert his innocence. In determining whether a sentence is excessive, the reviewing court is expected to assess the aggravating and mitigating factors to determine whether they were based upon competent, credible evidence in the record. An appellate court is not to substitute its assessment of aggravating and mitigating factors for that of the trial court. However, when an appellate court determines that the trial court has found aggravated and mitigating factors unsupported by the record, the appellate court can intervene and disturb such a sentence with a remand for sentencing. Okay. The only exception arises where a sentence shocks the judicial conscience. For example, in State v. Rivers, where the jury convicted the defendant of multiple crimes involving a gun, we found that the defendant's consistent denial of involvement and his lack of remorse indicate that a prison sentence is necessary to deter a defendant from similar conduct in the future, and therefore the trial court properly found aggravating factors. The trial court was required to sentence defendant to a minimum of 25 years in prison with 25 years of parole disqualification. The sex offender psychological examination required under NJSA 2C47 found insufficient psychological evidence to conclude that the defendant felt irresistibly compelled to commit the present offenses, and thus he was not eligible for sentencing under the purview of the New Jersey Sex Offender Act. The trial court imposed a 30-year sentence with an 85% parole disqualifier and a concurrent 5-year sentence for endangering the welfare of a child. The court found as a mitigating factor defendant's lack of prior record. The trial court found aggregating factors 3, the risk of recidivism, and 9, the need for deterrence, outweighed the single mitigating factor. Similar to Rivers, the trial court based these findings on defendant's lack of remorse or acceptance of responsibility, given his admission to sending the sexually explicit text messages, but denial of sexually assaulting BP, and his attempt to explain away the text messages to the pre-sentence investigator. Furthermore, the trial court noted that defendant's grooming of the victim and his repeated delete everything commands to BP fully support a conclusion that defendant knew what he was doing was wrong. The trial court found that a significant period of incarceration is required for the protection of the public, and I agree. The sentence imposed an additional 6-month mandatory minimum to the required statutory minimum. In light of the victim's suicide attempt, Presumably, as a result of the defendant's assault, the additional time in prison does not shock the judicial conscience. The trial court's sentencing determination was predicated on the competent, credible evidence in the record, and thus defendant's sentence is not manifestly excessive. I agree. So what do you guys think about the Arthur Wildgoose appeals? Do you think the 30-year sentence imposed on Arthur Wildgoose was excessive? And what do you think about the Jessica Lansford Act, which prescribes a mandatory 25-year sentence for aggravated sexual assault of a child under the age of 13? Do you think that's an excessive sentence for that crime? I'm very curious about what you all think, so please leave your thoughts in the comments, like and subscribe, and until next time, keep it sassy.